Yes, over the years, I've kind of done everything. Like I tell family and friends, the only thing that I've not really done are those types of areas that people usually want me to have practiced in, like criminal and family law. But certainly over the years, I've seen enough to kind of put together kind of this amalgamation of greatest and worst hits. Because what better way to learn how to do something or what the best practices are than to see some of the worst practices. And having encountered it, we get to kind of go down memory lane a little bit, and I get to relive some bad moments. So anyway, but yeah, as Susan alluded to, I've been practicing with Locke right out of law school. I've been with the same firm for just over 22 years, which is kind of a rare thing these days. And during my career, kind of dabbled in a number of things, but currently my focuses a lot on products liability litigation in the healthcare field in particular, but also in aviation and defense contractors. I've also been involved in a number of government-led investigations as well as enforcement proceedings. I handle a lot of TTAM or False Claims Act litigation, which is, as probably many of you know, just kind of statutory fraud claims where the government is the party in interest, although the party bringing the lawsuit is sometimes a whistleblower or a self-proclaimed whistleblower represented by plaintiff's counsel. But in the end, the allegation is essentially that the government has paid money that they otherwise should not have or ought not to have paid, but for the alleged misdeeds of the defendant. And then I'd also do a lot of just commercial disputes, whether it be breach of contract in the real estate or corporate context. But oftentimes I get pulled in when there's allegations of fraud, and some of the more interesting ones actually involve claims of forgery, which with e-discovery and our great resources here at the firm, you're able to go in there and almost do forensic type work on the fly and find documents that get altered and then passed off as originals, which can lead to some interesting results. What I always like to tell people is trial work is a lot like looking at kind of the iceberg. The trial portion is only about 10% that you see above the water. Everything else is below the surface, and that's obviously the bulk of what we do. It used to be that trials were probably the most fun that a trial lawyer could have. I always refer to it as the dun 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 moments. That excitement where you unveil something during the course of a trial that just is kind of shock and awe. But while the jury may be surprised anymore now, by the time you get to trial, everything is largely scripted. And the idea of calling in a witness, unannounced, undisclosed, you just obviously can't do that except for some rare situations. I always joke and say the days of, calling in that witness or bringing out that document or that piece of evidence that the other side hasn't seen before, if you do that, then they're going to move to strike it because it hasn't been produced or disclosed. And then instead of being exciting and ooh and ah, you've got to call your malpractice carrier. So anyway, the most fun that I have now is taking depositions, because that is kind of where the rubber meets the road now, because that's where you can still have that element of surprise. And while there's nothing better than taking the deposition of somebody on the other side, and then you kind of catch them in a position that then you get to pull out the documents, the emails, et cetera, and impeach or otherwise drive home your point. The worst moment is when I'm defending the deposition and I've got that client or that witness or that officer sitting next to me, and he or she's on video, I'm not. And then out come these documents, these emails that maybe we've seen before, maybe we haven't. And then the witness has to answer for them. And sometimes it's things that they've prepared, in which case maybe they can explain it. Or it may be that it is so inflammatory and such a powerful document that the plaintiff's lawyer is using something that a lower level employee authored, and they're putting that in front of the president or the CEO or somebody higher up in the organization, and they've got to answer for it. So having done that and having been through that, that's kind of what this is based on. It's kind of looking at now with the proliferation of email, what can go wrong, and how might you as general counsel or and your employees maybe take steps to try to avoid that, which admittedly is difficult in the era of COVID. So what we'll cover today, again, our email and text communication best and worst practices. That also extends to IM communication or team texts and all these other methods of communicating and writing that with their ease and their tendency of not ever being fully deleted that we have to account for, be prepared for. We'll also cover how to properly invoke and preserve attorney-client privilege. It's gotten harder and harder to effectively invoke it, but it's gotten easier and easier to waive it and to let it slip away. I'm going to kind of go through some kind of tips on things to maybe think about when trying to manage this internally. I'm going to touch on some authorized or unauthorized signatory issues just because I've been seeing a lot of that, and given some states choice of law provisions and how those find their way into these kind of gotcha contracts and the issues of apparent versus actual authority, something that I want to kind of bring to everyone's attention and be mindful of. And finally, we'll just kind of close out with some thoughts on kind of what to do and what to tell our business folks to do or not do when things get a little hairy, when things go sideways. So starting off with email best practices. It's always good to lead off with a quote. So this is one from a Boston politician in the 1800s. Never write if you can speak, never speak if you can nod, and never nod if you can wink, which just sounds so prophetic. But the fact of the matter is, they didn't have emails or text messages or all the other things that we have today back in the 1800s. So it's kind of, inapropos, didn't really apply to what we as outside counsel and what you as general counsel have to deal with on a daily basis, because you just can't tell people to stop communicating. I mean, you got to deal with it. Some of the best advice, it's simple advice. I always tell people, always take a moment to think about what you're writing. Resist the ease and efficiency of sending an email or text, which I know now is so difficult, and it's easy for me to sit here and tell you all that we need to be telling our folks to try to resist that temptation. But I understand, as you all do, that the fact of the matter is that with COVID and not having real time and people working in their own schedules, it just doesn't lend itself to just picking up the phone and calling someone when they may be on a different schedule or dealing with other issues while at home. And in the temptation and the ability to work efficiently is such that you want to knock the ball back over to the other side of the net. So what better way to do that than to send the email, get that off of your plate so that the recipient can then work on that as her schedule permits. So we're even more dependent on email traffic. All the more reason, however, to be cautious in how we communicate. And then one of the things to think about, obviously, is the reach of the communications, being more tailored. Instead of just sending out an email to everyone, give thought as to who or whom it is that you're looking for input or information from. Maybe do some due diligence on the front end to figure out who is the best person with whom to communicate about a particular subject, especially if you're doing any sort of investigation or something that may tread upon privilege issues. And of course, try to get folks to refrain from using reply to all or distribution lists. Not only is that not an effective way of communicating and perhaps invites greater chaff, and probably invites some side discussions out there between and among people, but it also runs the risk of potentially taking what would otherwise be a privileged communication and putting that in peril by over distributing it, and through that dissemination, thereby waiving the otherwise applicable privilege. Now, and this is where it gets kind of fun, because now we get to look at some examples of what not to do. But I always tell people, avoid exaggeration and inflammatory language. Using superlatives or trying to draw conclusions or doing something in an email, that's never good. One, it's just not an effective means of communication. But when you try to tell your business folks that kind of goes in one ear, out the other. And so it's you almost have to give them a tutorial of what could possibly happen down the road. And that's why it's always interesting when I've worked with witnesses and I'm going through their emails to discover that they don't really have it, and they're pretty tame. And I'll ask them, you've given a deposition before, haven't you? And they say, yeah, I have. And that's kind of the best and worst way to learn some of these lessons. But here's some examples. This is an oil and gas case that I had a while back. And the background of the case was this, that there was an oil well that was prepared and the casing collapsed. And as a result, the well was lost and it was essentially scuttled. And so the lessor brought a lawsuit claiming negligence and sued the operator. And we get involved in discovery and we start pulling up these emails. And one of the email chains that we came across were between these two employees, Sam and Tim. And neither Sam nor Tim had anything to do with this operation. They'd never been out to the field. They hadn't worked on this project. They didn't know anything. But what they did know is they didn't like the guy that was running the operation. And so after all this happened, they engaged in this little email exchange where Sam writes to Tim, "Hey, Tim, I just spoke with Steve about the accident. Reading between the lines, it's clear his team really messed up and caused the casing to collapse. It's a wonder no one was hurt or worse. That's what Steve gets for protecting Alan. Everyone knows he's incompetent and a danger on the job. Have they come to talk to you yet? Shoot me a text or a personal message when you talk to them. Probably should be on the same page. Thanks." Well, Tim writes back and says, "Sam, thanks for the heads up. I'm hoping they'll leave me alone. I don't think they want to hear all the things I could say, ... I think some folks' incompetence and stupidity are going to really shine through." And then just to make sure that nobody would ever see the email, he concludes with, "Delete this." So you can imagine that when the plaintiff's lawyer got his hands on this, he had all kinds of fun. And during the course of the case, he realized that Sam and Tim didn't really have anything to do with it, but he still used the email, but he used it with one of the officers in the company. And as a result of that, we had to deal with this just because you had two folks engaging in an email exchange that they should never have done in the first place. It's almost like sometimes folks like to use this as an airing of grievances, kind of from the old Seinfeld episode, the Festivus episode, the airing of grievances and emails. And all that does is set it up to where somebody else may have to answer for it. So with emails, we need to caution people to watch it with forwards and attachments. Those all become discoverable in litigation. Also give thought to the fact that we all get emails from friends, whether it be in the company or outside the company, and there may be some levity to it. And I know one client, and I didn't really touch on this, but I've been involved in the opioid litigation. And there's been all kinds of inflammatory emails that have come out of that case. We'll look at one here in a moment. But one of them was where there's a video that gets floated around. And the client didn't make the video, and they didn't really have didn't reference them. But then they forwarded it on. They passed it along to other people within the organization, and it was one that kind of made light of the opioid epidemic. And it wasn't that the company itself was making light of it or didn't take it seriously or was otherwise a bad corporate citizen, but all it takes is a few people to be passing around something like that or trying to make humorous statements about something, but in doing so comes off at a minimum as being tone deaf. At worst, it's belittling what is otherwise the cause du jour, and obviously plaintiffs' attorneys like to latch onto that. What better way to show that whole theme that we always hear about, profits over people, than to start showing emails and forwards and things like that, where folks within the company, albeit not decision makers, are not taking something seriously. Obviously, you got to consider public perception. I mean, even with protective orders in place, once a case goes to trial, a lot of that stuff finds its way into the public domain. And just the thought of it being up on a big screen or otherwise being covered by the media or published in a Law 360 article, that comes out every day. And so the proliferation of these things can be very, very harmful. I always tell people, it's kind of the whole dragnet idea of just the facts, ma'am, telling people to try to avoid conclusory language, fair and reasonable when talking about a contract or its terms, or using loaded terms like liable, negligent, compliant, or non-compliant, or responsible, fault, breach, violation. All of those are words that, while we may use them in kind of common parlance, if it's in the context of legal matters or potential legal matters, they kind of take on a life of their own. It really doesn't matter whether or not the person using them is herself a lawyer or not. Here's an example. This was a case involving an operator of a small aircraft that crashed, and no one was killed, but it did result in some injuries and property damage. But one of the issues was whether or not they had implemented changes in the manual that had been recommended by both the manufacturer and the FAA. And originally, when the case was filed, the theory of liability was one of the mechanics, that something wasn't placed on the aircraft that should have been placed on the aircraft. But once they got a hold of documents, it's a classic example where the plaintiffs kind of discover their case, and which can be kind of frustrating when they're out there kind of looking for something, and then they wind up getting what they need to survive a summary judgment motion or something to get to the jury that they didn't otherwise have just because of an errant email like this. And this is one where one employee writes to another down at the bottom. I've been incredibly delinquent in getting back on this. My apologies. I've been talking with people or folks in the engineering and trying to get them aligned ahead of our upcoming attorney meetings. Do you all have time to meet this week regarding the HDS system and the post-2015 alterations, changes to the manual? And the other employee writes back, works for me. I saw Miles last week and had talked to him about those revisions to the manuals and the ops layout. He said we were probably slow in rolling those out per the manufacturers and the FAA guidance. Not great, not horrible. But then he writes, can anyone say negligent? Now, why in the world someone would want to put that in an email? And why they did this, I don't have a clue, because by the time we got into this case, this person didn't even work at the company anymore. But it kind of speaks for itself, and that it doesn't really say anything. At the same time, it says a lot. And as a lawyer who's trying to defend the case, when you get something like that, it just creates more work. It's just kind of frustrating. And, in any case, it doesn't really matter how big it is. A lot of times it just comes down to a handful of documents. And a lot of times those handful of documents themselves don't really have a whole lot of substance, but they'll have verbiage like this that a jury sees and they can latch onto it because it's simple, it's concise, it's a perceived admission. Anyway, and then we'll touch on the rest of this email in a little bit when we get to the privilege portion. But you'll notice that then the person responds back. We should definitely take that up when we meet next week, ceasing legal to protect. So give that some thought on what that accomplishes. Don't be the author of the hot document that makes the other side's case and makes you their star witness. And it's easy to tell our business folks that, but frankly, until you kind of do a mock examination or they actually have to sit through a deposition and answer for something, it's really tough to really take that home. But here's one of the examples. This is in the opioid litigation, and I think everybody's probably somewhat familiar with the 1,000. There's probably about 4,500 of these cases floating around. Most of them are consolidated up in Ohio in multi-district litigation. But in short, the allegations are essentially that the counties and the healthcare systems are suing the manufacturers, the distributors, and the pharmacies for not discharging their obligations under the law to monitor the dissemination of the highly addictive opioid medications. And this is one example of an email exchange back in 2009, which really is the height of the opioid epidemic. And in this exchange, it's between an opioid manufacturer, not just a low-level employee, but a national account manager, and a customer regarding the shipment of 1,200 bottles of oxycodone. There's 30 pills in a bottle. This is where the customer writes to the manufacturer, keep them coming, flying out of here. It's like people are addicted to these things or something. Oh, wait, people are, which is a horrible email, right, for the customer. But the customer really wasn't in the crosshairs of the plaintiffs in this case. It's the manufacturers, because the manufacturers are being accused that you knew of or you should have known of the highly addictive nature of these pills, and that people were setting up pill mills and distributing all of these, and people were getting sick and dying. So the manufacturer's national account manager gets that, and you're thinking, well, would he respond, or how would he respond? I mean, you think that he probably shouldn't respond, but he did respond. He did respond, and what did he say? He said, just like Doritos, keep eating, we'll make more. So how do you get away from that? How can you, as a manufacturer, when your national account manager acknowledges that they are addictive, they're engaging in email communication, and what's more, are expressing levity to the highly addictive nature and comparing Oxy to Doritos. Anyway, that case settled. That was the case. In fact, I don't know. I think it was back during one of the vice presidential, or not vice president, maybe it was a vice presidential debate where that had just come out, and it was referenced in a debate that was held in Ohio where this case was pending. On the other side of the ledger, so putting aside just saying dumb things that are essentially admissions of liability or just flippant and just cast the company in a horrible light. The other side of that are, and again, most of this is aimed at people that are engaged in sales or promotional type activities for the company. And I get it, and I know you all get it, that a lot of times if you're involved in those activities, you get paid, or part of your compensation or your employment security is tied to how effective you are in driving sales. But sometimes that dynamic can lend itself to folks putting in emails verbiage that sounds a little too aggressive. So you got to watch out for instances where people are talking about offering incentives, where they're trying to drive decision makers, trying to influence, and I see this a lot in the healthcare context, especially on the manufacturer side, where they're trying to influence prescribers to adopt that manufacturer's drug regimen. And when you start seeing this coming up in call notes and other types of documents or marketing plans, it's really tough to then have to stare at the plaintiff's attorney who gets up there and says, these folks were on a mission to try to thwart and hold sway over these decision makers for the good of corporate profits over the good of people's health care, or whatever the practice is. And you also have to watch out for potential antitrust and anti-kickback type issues where people are talking about taking or stealing business away from the competitor, that kind of aggressive competitive vernacular that we all use. It doesn't mean anything, but in the hands of a plaintiff's attorney, they turn that on its head, and then they use that to try to cast that as the personality of the company. Same thing with being careful about talking, or not you all, but at least your business folks, talking about return on investment of certain activities, right? Because if the return on investment is, if we do this, then we will get this benefit, you again can run into potential anti-kickback issues in talking about that. And those emails just add as fodder, whether you're involved in a regulatory investigation or later if there's an actual lawsuit that arises either because of a whistleblower or maybe even the competitor brings a lawsuit under a theory of antitrust or unlawful monopolistic practices. Double deleting doesn't work. I mean, I always kind of joke and say that the delete key, I've got one right here on my computer, ought to have quotations around it because it never really gets rid of anything. Same thing with texts. Always have to caution people, although you really get people's attention when you tell them that if they use their phones or do use text messages to do any sort of business, then their phone, if there's a lawsuit, will get imaged, and they'll have to review the contents of it for discovery purposes. I find that once you kind of tell people that, they kind of stop using their phones for texting for business. But same thing with IM communications. We've got other forms of communication now that are also discoverable. I always tell people, when in doubt, pick up the phone or call via Teams. I mean, one good litmus test is always if there is an email or some text communication that you feel like you've got to get out right now and you don't even have time to think about it or breathe, that is precisely the kind of communication that should be the subject of a phone call and not something in writing, which is almost counterintuitive. It's like the more you want to get on your computer and type it, the more you should step away and pick up the phone and either call your supervisor or call somebody in legal before you start the paper trail. The other thing to always caution people is, even though you and I may exchange emails kind of joking about something, and And I know you've got my back and I've got your back. And I know that if somebody came and asked you for my emails, you're not going to give them to them, and I'm going to protect you, and I'm going to do the same. Employees got to understand it doesn't work like that. They're not active participants. The IT folks are. They are able to go in there on the servers and get everything. So the notion that you can communicate with somebody within your company or organization, and that will be held in confidence with the person with whom you're communicating. Once there's a subpoena, that doesn't apply anymore. Once there's discovery, it doesn't apply. And the other thing to keep in track of is, even if you're in an industry that maybe you yourself, your company doesn't get sued very often, therefore you're not really worried about being the subject of plaintiff discovery requests, you still may get hit with a third-party subpoena. I do work for a couple of private equity firms, and because they've kind of got their fingers in a lot of different pies, anytime there's a dispute, the first thing that they always seem to do, especially on the plaintiff side, is start reaching out to the PE folks to see what communications they had. What did they know? Maybe they can use some of their communications as almost a quasi-expert evidence on valuation type issues. But there's always, third-party subpoenas getting served. And so there's the risk that even if you're not involved in the case, all of a sudden some of your stuff comes out and sees the light of day, and maybe you weren't a target to begin with, but because of the emails, something else comes to light, and then all of a sudden you've got a problem that you otherwise wouldn't have had. Always ask people, how are you going to explain yourself if confronted with an email? The adage that I like to tell people is, say what you mean what you say, but then write it right. Be careful in how you communicate. Doesn't mean that you need to sit there and work on some, artful piece of prose, but you certainly don't want to be flippant. You want to be complete, and maybe sometimes you don't want to be overindulgent in the details, because maybe you don't know the details, and you're putting in a bunch of conclusory type questions. I've given this before to clients where I'm in person and there's like an audience, and I'll get a willing or unwilling participant, and I like to do kind of a sample deposition questioning of them, and I'll give them an email, that of course I've got, and I'll lay the predicate. And I mean, the way it works, the way that plaintiffs' attorneys do this, the way that I would do this if I'm on the other side, is I'll get somebody in the deposition chair. They're sworn in, they're on video. I'll ask them to introduce themselves, and I'll just lead them right where I need them to go. I'll ask them questions like, do you consider yourself a hard worker? Do you consider yourself somebody who is earnest and truthful in the way that you go about conducting business for the company? When you communicate with your fellow colleagues as well as people outside the organization, it's your practice to be truthful and forthright, is it not? I mean, you're the type of person that when you say something, you stand behind it. You're not in the practice of exaggerating or lying or trying to mislead somebody. And when you communicate with them, you're putting material information forward. You wouldn't intentionally omit anything. And so you just ask them these questions, and the answer is yes, yes, yes. Oh, of course. Oh, of course. And that when you put something in writing, you stand behind it, don't you? Yes, I do. Okay, well then I'd like to ask you some questions about some of your emails. And then you put something like this in front, which is the email that we looked at earlier, which is, okay, so I noticed that, and let's say I'm talking to Tim, who sent the top email. I don't think they want to hear all the things I could say. Well, Mr. Tim, maybe they don't, but I'll tell you what, I do. I'd like to hear all the things that you could say. And proceed. What were you referring to? Was it more than just talking about folks' incompetence and stupidity? I mean, you'd agree with me that being incompetent and stupid and working out in an oil field, that poses dangers and risks. So did you tell anybody about that? I mean, and all of a sudden, what do they say? Well, I didn't mean it. Well, you just got through telling us that you're forthright in your email communications. You say what you mean and you mean what you say. And so once you have something like this, you can't get away from it. I mean, it's so difficult. And then as the lawyer defending the witness, I'm there, and there isn't a whole lot I can do at that point. I mean, hopefully we have found these hot documents, and we can kind of come up with a preparation strategy. Although, again, you're somewhat limited, but usually I find the best way of handling something like this is to have Tim come out and say, look, I was mad at Alan and Steve because I was left off that deal and I was just venting. I don't think they're stupid. I don't think they're incompetent. And the fact that I didn't tell anybody about that is evidence that I didn't really think that. Because if I did, if I thought somebody posed a safety risk, I would have said something. I was just being a hothead and just venting to my buddy. And then that's probably usually the best you can do. But the best thing you could do is not put stuff like that in an email. I like Warren Buffett's advice. This is still applicable today. I've never regretted the email that I didn't send. I think we can all think of examples of late at night, whether it be, and this applies to everything, not just business communications, but anytime after hours that you get something, maybe you've had a glass of wine or three, and you want to respond either because you want to knock the ball back on the other side of the net, or because you're worked up and you just want to get something off your chest. But if you put it down, and if you come back the next morning and think about it, I don't think anybody would ever say, man, I wish I'd sent that email or that text last night at 10:47 because that would have had so much more oomph. And now if I send it at 9:47 this morning, it's not going to count for as much. I don't think anybody has ever had that regret. And of course, unfortunately, like a lot of things, you don't really learn it until it's too late. Privilege. I think everybody kind of has a sense as to what it is, but I tell you, this is what privilege represented about 10 or 15 years ago, and I don't know if y'all can see me, but I'm holding my hands up in like a circle. It's now like this, and in 5 years from now, it's going to be like this, and it's just getting smaller and smaller. And the truth is, courts don't like privilege. Kind of the premise is let the sunlight come in, let everything come out. And so if we're going to try to invoke privilege, you got to be real careful. And the other thing you got to be careful about is because of the large volume of documentation, you can't claim privilege on everything just because, we're going to look at some stuff here in a second, but you got to be mindful about how vigorous you want to assert privilege when it comes to putting a privilege law together and having a judge look at things. Some questions. This is again where I have people show their hands and I kind of take a hand count, but I'll put y'all on your honor. If you include legal counsel on an email, the email is presumed to be privileged unless proven to be otherwise. True or false? False. There is no presumption. By labeling, well, there's one exception that I'll come back to that. By labeling a document or email privileged in the header or subject line, courts will usually defer to such designations. True or false? False. There is no deference given anymore. Forwarding an email chain to or incorporating an attorney into an email discussion will extend privilege protection to the earlier exchange. That's a little wordy, and we're going to look at an example, but that's also false. For the attorney-client privilege to apply, there's certain criteria that have to be met. Now, keep in mind that privilege is one of these things that can fluctuate based upon the law of a particular jurisdiction, whether it be in federal court, in the federal jurisprudence that surrounds privilege, or individual states. And so depending upon the size of your organization, your company, you sometimes need to be thinking, well, what's the most restrictive common denominator out there? Because while New York, California, Texas, and Illinois may have a certain standard, if you're getting hailed into court in Kentucky or some other states, it's probably worthwhile to look at what their standard is, because if you get sued there, you may be held to that standard rather than where you're domiciled or doing business, or even where the communication took place. But in any event, generally, this is the rubric within which privilege is evaluated. One, legal advice must be sought. And I highlight legal as opposed to compliance, regulatory, marketing, all the other disciplines. And compliance can get a little closer, regulatory can get even a little bit more close, but in the end, there are jurisdictions that have now taken the position that that is not privileged. In fact, going back to the opioid litigation, Judge Polster, who's presiding over the multi-district litigation in Ohio, he has taken a very limited view in construing privilege, such that regulatory advice. So if you've got folks saying, hey, if we do this, this is in compliance with our obligations under Controlled Substances Act, but it's coming from somebody who's in charge of compliance and regulatory, that's not getting treated as being privileged if legal is not involved. So he's drawn a line between those two spheres of advice. Moreover, the advice must be from an attorney in his or her capacity as such. And what that means is just because your chief compliance officer has Esquire after their name doesn't mean that they are, quote, an attorney, so that the attorney-client privilege applies if legal advice is not being sought. And that's what it turns on, is a judge is going to look at each communication in and of itself. And that's where you got to be careful in going in there and saying, here, Your Honor, here's a stack of 10,000 documents that we are invoking privilege on, because you run the risk of the judge getting angry and then taking his hand and then just wiping it all away and saying, even if there was something in there that's privileged, because you've over designated, because you're putting this in front of me, I'm going to deem it as having been waived as to those documents for which it was otherwise being meritoriously asserted. The communication must be related to that purpose. Again, you got to be seeking legal advice or dispensing legal advice in case of in-house counsel. And the communication must be made and kept in confidence so that it would not be disclosed. And that kind of ties back into my earlier point about good communication practices, about limiting your audience, being very targeted. That is especially true when you're dealing with issues of privilege. And one way of thinking about it is, the attorney-client relationship, whether it be, my relationship with my clients or your business people's relationship with you, it is in some ways an intimate relationship. You don't go into an attorney's office with your family and friends and expect to then engage in a privileged discussion. Likewise, I don't reach out to my attorney and copy a whole bunch of other business folks within the company even, and expect that to be consistent with seeking legal advice. Same thing with dispensing legal advice. I know that there's some exceptions when there's a pronouncement and we've got to advise all of our employees that we need to do this to be compliant with the law, and we must refrain from doing this because, I'm advising you as in-house counsel not to do this. But otherwise, if you send out an email or some broad, proselytization on something, the scope of that communication really cuts against the privileged nature of it, and it gets harder to defend the more recipients and the larger the audience. Because privilege has two prongs. There's an objective and a subjective prong to it. Encouraging our business people to label legitimate communications as privileged and confidential, that's good, because then that shows that at least subjectively they thought that they were seeking legal advice. It still may not meet the objective standard if the nature of the question or the ask still isn't actually soliciting legal advice, but at least that gets you over the hurdle. But at the same time, and that's what the next point talks to, that's not evidence of privilege. You can't rely on that and say, well, because it's stamped privileged and confidential, it's therefore privileged. And again, privilege applies only to the communications, not the underlying facts communicated. And what that means is in situations maybe where you've got an accident, let's say, and you have an employee who says, God, this is really bad, but I'm going to write it up in an email and I'm going to communicate this to my lawyer. And in doing so, I won't ever have to ask any questions about it because it's all privileged because I put it in an email to my attorney. No, it doesn't work like that. But just because you put that in an email to the attorney, first and foremost, if you're just sending that and you're not doing that as part of seeking legal advice or because the lawyer asked you to write it up and is overseeing that so that there's some attorney work product, the underlying facts themselves are discoverable. You don't get to kind of claim King's X that all that information, those facts, are now off limits because it found its way into a report or something else that itself may be privileged, which is a good caution to people. It's like, hold off before you start writing these massive missives on what happened. This is a good example of where it's probably better to get on the phone and let's start talking about things before we start generating an email paper trail on everything. Let me see if I can find that one email real quick. Okay, I'm going to come to that one. Someone had a question on that. Copying an attorney on a business-related email or inviting the attorney to weigh in on non-legal issues likely will not invoke privilege. Again, it's got to be seeking or the provision of legal advice itself. Sending a marketing plan, for example. I mean, I think we've all seen these, even if it was when we were working in law firms or in law school and coming up with examples. But taking a marketing plan and stamping subject, privileged and confidential, subject to legal and regulatory review, not privileged. Because unless there's some transmittal or something where you are actually seeking legal advice, stamping that on that document does not act as some sort of prophylactic protection so that it doesn't get produced and it can be kept or withheld on a privilege law. Email should be directed to counsel with a tailored and limited audience. You know, that's kind of what I've been saying over and over again, probably. And don't copy and add extra people to an email chain, because the problem is if I'm the lawyer, whether I'm outside counsel or I'm in-house counsel, and I'm communicating with employees as part of an investigation, which if I'm doing that, I'm leading that, and certainly if I'm outside counsel working with you and doing that, that has all the imprimatur of being privileged. That's attorney work product right there if we're doing this. And it's because we're anticipating litigation. But if we send an email to Ms. Smith asking her, hey, we want to get your thoughts on this, that communication back and forth has a good chance of being privileged. But if she writes back, and let's say we put some color in it as counsel saying, you know, here are the issues, here's this, here's that. But then when she writes back, she goes, I don't know anything, but I'm copying Ben and John who were working that night, and maybe they can help out on this. Well, you've got a situation where potentially privilege has now been waived because now she's sharing that with people outside the control. Whereas the better practice would have been for her to write back to me or to you and say, I don't know anything about this, but you ought to reach out to Ben and John. They were working that night. They probably know more. Because then we can reach out to them and have those communications, and that's privileged. Whereas if the employee is acting as kind of the hub and trying to facilitate things, when we're not asking them to do so, you run the risk of breaking that privilege by pulling in too many people. Here's an email that we looked at earlier, and I had touched on this, that ceasing legal to protect. The reason why that doesn't work is there's no legal advice being sought. I mean, this is the perfect example of where this in the Tim and Sam, this is where the employee realized, oops, we just engaged in some communication. He saw his buddy's comment down here, can anyone say negligent? And now he's trying to put the horse back in the barn by ceasing legal to protect this so that all of this down here magically becomes privileged. It doesn't work like that. It doesn't work like that. Now, if the employee had said ceasing legal to protect and to invite their input and advice on whether or not what's laid out below amounts to negligence, that would be privileged. That would be privileged. But that would only apply to that top email. It wouldn't extend to everything else down here. Because once this is, because there's no lawyer down here. There's no legal advice being sought. There's no communication about legal thoughts other than a non-lawyer, stating something in a conclusory fashion as being negligent. I touched on this earlier. I mean, this is unfortunate, but regulatory and compliance advice is getting less and less deference every year as being privileged, even if it's being handled by someone who is a license or holds a JD, who's a lawyer. Involvement from outside counsel can always help. I always tell people, it's somewhat self-promotional, get me involved and all of a sudden you'll be safe. But the truth is when courts look at whether or not something is privileged or not, one good indicia of that is if the company has retained and pulled in outside counsel, because what better proof than expending the money and pulling in outside counsel to showing that we're really anticipating litigation, and B, we're really engaging in substantive privileged legal communications. In some jurisdictions, you got to look at the primary purpose of the communication. Texas is not one of these jurisdictions, meaning that even if part of the communication touches on legal, where there's asking about legal, but then everything else in there is regulatory, the privilege still applies. And it may even apply to the whole document, or a court may come in there and say, well, you need to redact out the part that's legal. But it's not a situation like you see in other jurisdictions where is if the primary purpose is not legal and you bury a legal communication in an otherwise non-legal communication, it's waived. But you got to be careful. I mean, I know all that does is probably invite more email chatter, not less. Advice regarding business, technical, scientific, etc. Advertising, not privileged generally. Here's a good example of where somebody thought they were doing right, but they weren't. This was in the context of a pharmaceutical manufacturer, subject line, marketing and rollout plan. You notice that they've CC'd somebody from legal. It's from a regional business director to the marketing team, another business director, and a number of other individuals on the sales team. And then it has Mr. Chester listed in the CC field. And they even labeled it privileged and highly confidential. And I will tell you, I think some companies have automatic headers, because this showed up a lot in this case, where everybody was misspelling privileged with that D. So make sure you spell it right, because that kind of looks funny if you're going before a judge and you're trying to claim privilege and he says, hell, they didn't even spell it correctly. But this is a close call, or at least potentially could be. And this is where Sam is writing to the team, right? He's sending it to the team. Attaches a draft slide deck for the upcoming product rollout. While we await final approval, we need to schedule a time to go over FDA guidance and the approved deliverables and leave behinds. As you know, and again, he's talking about FDA guidance, that's legal, that has legal implications. As you know, we're not yet approved for use in the child and adolescent population. In the meantime, we need to obtain alignment within the group regarding scope of pitches and avoiding off-label promotion situations. And I highlight that because off-label promotion is both it's a crime. It's a white collar crime, and it also subjects you to a civil liability. So obvious legal implications. Given the favorable literature, we should be able to leave these materials and let the doctors draw their own conclusions, with perhaps some nudging from us to help them make the right prescribing and dosing decisions. Amin will send around an invite for next week's event. And this was an email that the client did not want to have produced for obvious reasons. I mean, it was fine, except for that part about there with perhaps some nudging from us, because that kind of shows that they're mindful of off-label promotion, yet they're getting ready to do it. And so there was a fight on this. It's a losing fight. This is not privilege. I don't know of a court that would uphold privilege on this, and this is why. Nowhere in here is there any request for legal advice. Nowhere in there are they asking Mr. Chester to weigh in on the legal rightness or wrongness of that. It's addressed to the team. It's already being done. And this is one of these instances where it's kind of a CYA copying of legal, because the person thinks that by copying them, because they're on the email, that ipso facto makes it presumptively privileged. In fact, presumptively, this is not privileged for those very reasons. There's no advice being given. Now, if Mr. Chester were to write back and dispense legal advice, that communication would be privileged. But if he did it, he's doing it in almost an unsolicited way because he's not being asked. He's not being asked. There needed to be a question in there that was at least somewhat, or have some nexus with seeking legal advice. Again, I've touched on these with those two examples. Labeling something highly confidential doesn't make it confidential. That's kind of an aside. That's not really a privilege issue. But you see people where they'll label something not just confidential, that's highly confidential. And every time I see that, and when I was in high school and I was thinking about going to law school one of these days, the movie A Few Good Men came out. I just loved that movie, and I still love that movie. And every time I see highly confidential, it always reminds me of the scene where they are in court, and you've got Demi Moore, who stands up and objects. She's overruled, and then she says, "But I strenuously object." And then Sam Weinberg says, is that how it works? I object, overrule, I strenuously object. It's the same thing with confidentiality. Confidential? No, it's highly confidential. That doesn't mean anything until you get involved in litigation and there's a protective order, and maybe you've got two tiers, kind of an attorney's eyes only type tier, because it touches on competitive type information that you don't want business folks on the other side of the case seeing, but it doesn't otherwise give it any heightened protection from production in the first instance. Privilege, it can be waived. It can be waived so easily. And I think we've talked about examples where that can happen. But the biggest fear I always have is where it gets waived, not just as to that document, but to the subject matter itself. Because if you talk about something that's otherwise privileged and you send it to a third party, you potentially waive privilege as to the whole underlying subject matter of that communication. And here was an example. This was an email exchange involving where one company was hiring away employees from another company, and the issue was whether or not they could work on overlapping material without violating non-compete type issues. And this is one where the employee said, "Hey, I actually talked to Susan in legal about this set of issues last month. This isn't the first time this has come up. She told me that they're working on a licensing arrangement. They'll make it okay for you and some others to stay on the Sims team." All right. Other employee writes back, well, the other employee writes, "I hope all is well in your world. I've been concerned about that non-compliance issue with so-and-so. Looks like the legal folks have it under control, so I don't think we need to be worried anymore." The problem with that last communication is it's not internal. He has sent that to a buddy of his over at the other employee or the other employer, trying to grease the skids to get him to come over. And so what he's done here is he's taken a communication that was internal that provided a summary or synopsis of Susan and Legal's attorney work product, and has now waived it and sent it to the would-be competitor. Now, fortunately, they did reach an agreement on the licensing arrangement, but had they not, you've got a real situation where the other employer could come back and say, "I want to take Susan and Legal's deposition. I'm going to ask her all kinds of questions about this contemplated licensing arrangement," and get her to acknowledge and admit that the reason why they were doing that is because they knew that they were violating the non-compete provisions in the employees' contracts that they were hired. Another deal, and I'm just going to flip through this: be mindful about what you pass along to regulators. Sometimes employees will just forward along what legal has told them to the regulators, because it's easier than maybe sitting down and typing up their own thoughts. But if you forward that to legal or to the regulators, you've again forwarded otherwise privileged communications, and you could have a subject matter waiver situation. And while the regulators themselves may not do anything with it, you got to be thinking down the road. What happens if there's future litigation? What if that future litigation involves private plaintiffs' counsel, not a government lawyer? And what if that plaintiffs' counsel represents a large number of plaintiffs in multi-district litigation or class action litigation? So you can see how something like that will snowball. Kind of running out of time, but I do want to touch on authorized signatory issues. It may or may not apply to everyone, but be mindful that with these portals and all these ways to accept agreements online, that it's real easy to get bound to a contract, especially if that contract has a particular choice of law provision, like New Jersey. New Jersey's terrible, but your folks can very easily find themselves agreeing to something, even if they don't have the formal authority to commit the company. They still might find themselves engaging in actions or accepting something on a third party's website that could potentially bind them to an enforceable contract. Or they could also invite them to do certain tasks, saying, "Hey, I don't have authority, but while I get it, why don't you go ahead and advance the ball? Why don't you go ahead and start doing this?" Well, if they start to partially perform, same situation. And likewise, whether or not somebody has actual formal authority or not, may not matter. I mean, if the other actor jumps out there and starts performing, starts relying, starts purchasing things, and otherwise it starts expending their resources, you may still find yourself bound to a contract when they weren't authorized to do so. So anyway, just kind of going over the basics, step away from the keyboard, pick up the telephone, Again, the more urgent something is, and the more you feel like I've got to talk about it, the more so you ought to pick up the phone. Call your immediate supervisor and see if legal should get involved. You shouldn't, if things have gone wrong, the first thing you should not do is start emailing. Set up a call or a meeting with legal. And do not start deleting and removing emails. It just doesn't work. And then you potentially set yourself up for a spoliation situation. And I always tell people when I'm working with them as witnesses, and sometimes I'll even ask inside counsel to step out of the room just so I can get complete transparency from the witness. You know, what's the worst thing that can happen to us in the deposition? What are you most afraid of? You know, because whatever that is, there's a better than even chance that that will actually come to pass. And I'd much rather know about it beforehand so that I can work with them, or you and I can work with the witness on how to either embrace it, contextualize it, or otherwise deal with it in a way so that it's not just looming out there. Because if nothing else, it just serves as a distraction to that witness as he or she is sitting there through hours of deposition questioning and perhaps not focusing on the question at hand because they're worried about what's going to happen or what they're going to be asked after lunch and in the afternoon when things always get a little hairy. So anyway, I'll go ahead and stop there. I really do appreciate your time. Great opportunity. I always enjoy visiting with in-house counsel because I do understand what you all go through and having to walk that line between trying to do what needs to be done to protect the company, but at the same time not being perceived as an obstacle to the company's mission of trying to make a living. And I certainly welcome, or if I can ever be of assistance and be the bad guy to try to point this stuff out to your business folks, I've done that, and maybe that puts something between you and they that they can maybe take something away from. But thank you very much.
Thank you, Scott. Real quickly, you did have a question about what your opinion is on the necessity and benefit of P&C subject headers and the benefit of footers setting out privilege disclosure. Do you want to address that real quickly?
Sure. It used to be that when courts would give facial deference to that, you do it. But then, of course, what happens is everybody starts putting that on there, and you'd even see where that would be an autofill. It'd almost be like an automatic, your automatic footer or signature block to your email. It automatically puts in that header for privilege and confidential. And again, I'm focusing more on what business people do. Obviously, the communications that you all have with your folks as counsel, there is a greater likelihood of that being presumptively privileged, right? Because if you're communicating, we're going to take a good look at that and probably don't even need the privilege and counsel header on your communications. It's really for the business folks and making sure that when they are trying to, invoke privilege, that they're doing so effectively and they're doing it realistically, so that we don't have tens of thousands of emails and they all bear the same header and footer. Because the more that's in there and the more that becomes a default way of communicating, the less significance and the less deference that's going to be given by a judge.